From the moment the judge entered the courtroom, something felt off. Not in a dramatic, thunderous way, but in a subtle, unsettling shift that every person in the gallery sensed without needing to exchange a word. His steps were quick, purposeful, almost impatient, as though he had somewhere else to be or something else on his mind. The clerk could hardly keep pace with him. Lawyers shuffled their papers nervously, glancing at one another as if trying to read the energy of the room. Even the fluorescent lights overhead seemed too bright, too sharp, amplifying the tension that hovered like static in the air. The judge took his seat with a kind of brisk finality, tapping the edge of the bench with his knuckle before announcing, with clipped urgency, that the docket was long and needs to move. He didn't look at the defendant, didn't glance toward the counsel table, didn't bother laying out expectations or reviewing prior motions. Instead, he opened the case file with a snap and began reading in a voice that suggested he had already read it, already decided it, and was only going through procedural motions to justify a conclusion he had reached before the defendant even stepped into the courtroom. The defendant shifted uneasily in his chair, fingers curling around the edge of the table as though grounding himself against a sudden rush of fear. He could tell immediately that he wasn't entering a space where his arguments would be carefully heard or his concerns examined. The judge's rapid-fire summary of the case skipped essential context and minimized critical details. Every sentence he spoke seemed designed not to clarify, but to hasten. The attorneys tried to interject, politely at first, then more urgently, but each time the judge dismissed them with a raised hand or a curt remark about not needing to belabor the obvious. Witnesses in the gallery exchanged glances. They had seen rushed hearings before. Courts are busy places, after all. But this was different. This wasn't efficiency, it was impatience. It was a refusal to engage. It felt like a performance where the end of the script had already been chosen and everyone else was just expected to catch up. The defendant's attorney attempted again to speak, citing evidence that had not yet been reviewed. The judge waved it off, stating he didn't need every scrap of paper to know where the case was headed. That was the moment a cold wave rolled through the room. A case is supposed to be a deliberation, not a race. But here, the judge turned pages as though each one was an obstacle between him and something he wanted more: silence, completion, departure. His tone hardened whenever he had to pause, as if the mere act of listening inconvenienced him. The defendant's voice trembled when he asked to speak, and though the judge allowed it, the allowance felt forced, as though merely a box to check to avoid later criticism. But even then, he didn't truly listen. His eyes weren't on the defendant, they were on the clock. The defendant's story began, haltingly at first, then gathering strength, but the judge cut him off before he could finish a full thought, declaring that personal narratives don't alter the core facts. The defendant's attorney rose, objecting that key documents had not been reviewed, but the judge brushed the objection aside with almost visible irritation. The courtroom grew warmer, the tension thicker, each exchange faster and more dismissive than the one before. It was as though the judge believed his role was not to weigh evidence, but to shepherd the case to its conclusion as quickly as possible. Those watching felt a collective tightening in their chests as the judge turned another page without reading it. Something was wrong, something was being overlooked, and no one in the room, except perhaps the defendant and his attorney, seemed fully aware of how dangerous that oversight might be. Justice requires attention, care, patience. But none of those qualities appeared to be present within the hurried atmosphere orchestrated by the bench. The defendant looked down, defeated already, believing the momentum against him was unstoppable. He sensed that his fate had been sealed before he opened his mouth. Yet even as the judge read aloud with mechanical speed, even as he attempted to press the hearing toward an outcome that felt disturbingly predetermined, there was a growing unease settling across the courtroom. People noticed the unopened folder on the corner of the bench, placed hurriedly by a clerk earlier. They noticed the judge never flipping to the back of the file where supplementary documents were usually kept. They noticed the way the courtroom's energy felt strained, forced, unnaturally rushed, as if the truth sat somewhere in the paperwork the judge refused to slow down long enough to see. And beneath it all, like a low hum under the surface of the moment, was the growing suspicion that the case was not as simple as the judge wished to make it. Something had been overlooked, something that mattered, something that would soon break through the judge's impatient momentum and change the entire direction of the hearing. The defendant had prepared for this day with a level of fear that twisted his stomach into knots. He had rehearsed every sentence he hoped to say, practiced breathing steadily, practiced keeping his voice even and calm. But the moment he entered the courtroom and sensed the judge's impatience, all that preparation began to unravel. He felt the shift instantly. This was not a room eager to hear him. This was not a space where his words would be welcomed or weighed. The judge's hurried tone and clipped manner told him everything. He was not here to tell his story. He was here to be rushed through a process. His attorney urged him to keep steady, whispering that they would make sure the judge received the documents, but the defendant could see the tension in his attorney's eyes as well. The judge wasn't listening. The judge wasn't absorbing anything. He was merely moving past objections, moving past explanations, moving toward a conclusion so quickly that the defendant wondered if his presence even mattered. When at last he was given permission to speak, his voice caught in his throat, not out of guilt or uncertainty, but out of the weight of knowing that every word might be ignored. He took a breath and began, carefully laying out the timeline, the events that led to his arrest, the inconsistencies he hoped would matter. But before he could reach the point of clarity, the judge cut him off with a remark about irrelevant details and motioned for him to sit down. The defendant felt heat rise to his face. He wasn't being heard. He wasn't being understood. He was being processed. It felt like shouting into the wind. Even when he tried again, raising his hand, asking respectfully to clarify one point, the judge interrupted him with an irritated sigh. Every plea for attention was treated like a disruption. Every detail he tried to provide was dismissed as unnecessary. And yet he knew that the truth he carried mattered. He knew there was a document that would change everything. He knew the judge hadn't read it. He knew the clerk had tried to signal something was wrong. But the judge's pace, the judge's tunnel vision, the judge's insistence on speed over accuracy suppressed the truth beneath the weight of procedure. The defendant's voice cracked once as he tried to explain the connection, the name he recognized, the detail he had begged his attorney to highlight, but his words weren't allowed to land. Every explanation was drowned beneath the rhythm of a judge who wanted to move on. And with every second that passed, the defendant felt himself shrinking, his hope dimming, his belief in fairness growing thinner. Still, he persisted, even as the judge moved forward, even as the courtroom seemed ready to let the conclusion unfold unchecked, the defendant kept leaning toward the microphone, trying to find the moment when his voice would finally matter. He didn't know when or how, but he clung to the belief that the truth would surface, because the truth was in the documents, waiting to be seen, waiting for the one moment when the judge would finally stop rushing long enough to look. The stack of files sat on the far corner of the judge's bench, almost precariously balanced. Thin folders, thick folders, paper sticking slightly out the edges as if they had been gathered in a hurry. No one in the courtroom paid much attention to them at first. They looked like any other set of case documents, the type of administrative clutter that fills every courtroom and rarely holds anything extraordinary. But to the defendant and his attorney, that stack represented hope, fear, and unanswered questions all tangled together. The defendant had seen his attorney place a specific folder there that morning, marked with a colored tab designed to stand out. It contained the information they believed could unravel the assumptions driving the prosecution's narrative. It held the names, the connections, the overlooked statements that had been buried beneath the speed of earlier hearings. Yet the judge, from the moment he took his seat, never once reached toward that pile. He opened only the file directly in front of him, the preliminary summary, the simplest version of the case, the one that left out the complexities, the nuances, the critical evidence the defense desperately needed him to see. The defendant watched the judge's hands move, flipping through pages without pausing to absorb them, and he felt his pulse quicken. He could see from where he sat the edge of the crucial document peeking from the tabbed folder, almost calling out to be noticed. But the judge never acknowledged it. If anything, he seemed determined to ignore it. The clerk's eyes darted repeatedly toward the stack. She knew what was in the tabbed folder. She was the one who had reviewed it, the one who had flagged it for the judge's attention that morning. She had placed it in a position that would make it impossible to overlook. Except it had been overlooked. Or perhaps avoided. She watched the judge's movements carefully, waiting for him to reach for it, to slow down long enough to realize the weight of what had been placed so deliberately in his path. But his speed only increased. His gestures grew sharper, his irritation more obvious, as if the very existence of additional material irritated him. The page from the stack shifted slightly as the air vent kicked on. It fluttered just enough to catch the defendant's eye. He leaned forward, unable to stop staring at it. It was almost maddening to see the truth sitting right there, physically present but effectively invisible. The courtroom felt suspended in a strange tension, as if the stack itself held its breath, waiting for the moment someone would finally notice that it contained the answers no one else seemed willing to find. The defendant's attorney tried to reference the contents, stating firmly that the court needed to review supplemental materials, but the judge brushed him off with a wave of his hand, insisting that the primary file contained everything necessary. The attorney tried again, emphasizing that there was newly surfaced information, but the judge barely looked up. His refusal wasn't just neglect, it was a choice rooted in impatience or perhaps confidence, dangerous confidence, that he already understood the case well enough not to require additional context. But the truth doesn't disappear just because someone refuses to look at it. And in that stack of files, layered between reports and statements, was a name with the power to shift the entire case onto a different axis. A name tied to a relationship, a motive, a pattern of influence that no one in the courtroom had yet acknowledged. The clerk had recognized the significance the moment she read it. She had brought the document forward with urgency. She had tried to alert the judge before the hearing began. But even clerks have limits in a courtroom where hierarchy dictates what is seen and what is ignored. The defendant watched as the judge proceeded without ever touching the stack. Each minute that passed tightened something in his chest. He knew the truth was there. He knew that if the judge opened the folder just once, everything would change. The prosecution's narrative would crack. The rushed assumptions would fall apart. But none of that could happen as long as the file remained unopened. The entire direction of his life sat inches away from the judge's hand, yet might as well have been locked in another building. And then, in one quiet, nearly imperceptible moment, something shifted. A file at the top of the stack slid forward, just a little, pushed by gravity or vibration or something more intangible. It tilted enough for a corner to hang over the edge, and for the first time, the judge glanced at it. His eyes flicked toward the motion, his brow furrowed, not in recognition, but in annoyance at the distraction. But the moment mattered, because the clerk saw his eyes move, and she seized the opportunity. She stepped forward, clearing her throat gently, timidly. She pointed to the tabbed folder with a careful hand and said that the court may need to review supplemental materials flagged earlier. The judge shot her a look, impatient, questioning, but she didn't retreat. She stood her ground. It was her quiet courage that cracked the surface of the judge's certainty, her insistence delivered with a steadiness that made ignoring her impossible. For the first time since the hearing started, the judge's rapid momentum began to slow. His hand drifted toward the stack, hesitating, hovering above the folder that contained everything he had so far refused to see. The courtroom shifted when the clerk spoke. Subtly but unmistakably, her voice was soft, respectful, but threaded with a firmness that wasn't present earlier. She knew she was stepping into dangerous territory. A clerk interrupting a judge is almost unheard of. But she also knew what she had read. She knew the implications of the name buried in that file. Feel the defendant's desperate attempts to be heard were not random, not baseless, but tied to something far larger than the judge's rushed summary allowed room for. Her warning began gently, a simple reminder of flagged documents that had yet to be reviewed. The judge responded with irritation, questioning why she felt the need to intervene. But the clerk didn't back down. She repeated with carefully chosen words that the material was critical for accurate adjudication. She chose that phrasing intentionally. She knew that no judge, no matter how impatient, could openly dismiss the notion of accuracy in the record. She used the one angle that left him no dignified way to reject her concern. The gallery sensed the tension instantly. They watched the exchange with a kind of quiet awe. The defendant straightened in his chair, hope flickering back into his expression. His attorney leaned forward with renewed focus, recognizing that the moment he'd been praying for might finally be unfolding. The judge, however, bristled. His face tightened, his jaw shifted, but even he understood that ignoring the clerk's insistence could expose him to scrutiny he could not afford. He demanded the file be handed to him. The clerk complied, placing it gently before him, her hand steady though her pulse raced. The judge opened it with a kind of reluctant defiance, as if expecting to prove her wrong, to show that the contents were unimportant. But the moment his eyes fell on the page with the highlighted name, something in his expression changed. The irritation drained away, his posture stiffened, his breathing slowed. The courtroom watched the transformation unfold in real time, a judge moving from certainty to shock. He read the name again, silently, then again. Confusion washed over his features, followed by recognition. His eyes flicked toward the defendant with a new kind of calculation, a dawning understanding that the story he had dismissed might not only be valid, but dangerously accurate. The clerk stood perfectly still, waiting, knowing this was the moment she had risked everything for. And then the judge asked the question no one expected him to ask: whether all parties were aware of the identity revealed in the supplemental document. The answer, of course, was no. Only the defense had tried to bring it forward. Only the clerk had tried to make it known. The prosecution shifted uncomfortably. The gallery whispered. The defendant exhaled a breath he'd been holding for hours. The judge's entire demeanor changed as he reread the document. His tempo slowed, his tone softened, his certainty fractured. In one quiet warning, delivered with the courage of someone who understood the stakes, the clerk had dismantled the false momentum of the hearing and forced the truth into the light.
At first, the judge's reaction to the clerk's insistence was irritation so thinly veiled that everyone in the courtroom could sense it. His eyes narrowed slightly, jaw tightening as though he could not believe he was being asked to slow down. He had entered the courtroom with the confidence of someone who believed he knew exactly how the day would unfold. The defendant was a small case in his mind, one of many, one that didn't require deep thought, one that he believed would move quickly through his docket. But when he opened the supplemental file, his confidence faltered. The shift was subtle at first. A small crease formed between his brows as he scanned the first page. His lips parted slightly as if his mind stumbled over what he read. The clerk had highlighted a section in soft yellow, and his gaze lingered on that block of text, far longer than expected. He turned the page slowly, no longer in the rushed, dismissive manner he had displayed earlier. Something in the words unsettled him. His impatience began to fade, replaced by a dawning awareness that the case was not what it appeared to be. The courtroom watched him closely, everyone sensing that something unexpected had surfaced within those pages. The judge straightened in his chair, leaning closer to the document, reading it again with more scrutiny. His eyes flicked toward the defendant, not with disdain this time, but with something closer to unease, perhaps even wariness. It was as if the judge realized he had spoken too soon, moved too fast, and now found himself grappling with the possibility that he had nearly made a grave mistake. His fingers drummed lightly against the wood of the bench, an unconscious sign of nervous energy. He did not look at the prosecution right away, nor at the defense. Instead, he stared at the text in front of him, the highlighted name that seemed to burn through the page, demanding acknowledgement. The courtroom remained silent. Even the sound of people shifting in their seats subsided, as if the entire room had been submerged beneath a sudden pressure. The judge cleared his throat, once, sharply, then again more softly, as if steadying himself. He flipped through the rest of the pages, finding connections and references that had been buried in earlier reports. Some of the notes referenced communications that had not been reviewed in prior hearings. Some indicated relationships between individuals listed in the case that he had not known existed, and all of it pointed toward a broader narrative that cast doubt on the rushed conclusion he had been ready to issue. His annoyance dissipated entirely. In its place grew something far heavier, the sinking realization that the defendant had been right to insist on being heard, that the clerk had been right to intervene, that he, a judge who prided himself on fairness and efficiency, had come dangerously close to letting haste override justice. He leaned back, exhaling slowly. His hands, once decisive and abrupt in their movements, now rested still on the bench. He glanced briefly toward the gallery, as though searching the faces there for confirmation that the truth he had just encountered was not a mirage. No one spoke. The atmosphere was thick with expectation. When he finally lifted his gaze fully, it was to look at the defendant, really look at him, perhaps for the first time. The judge's eyes held something almost apologetic, though he would never voice such a sentiment aloud. But the shift was visible enough for the defendant to notice. Something inside the defendant eased, but only slightly. He still didn't know what the judge had found. He only knew that whatever it was had been powerful enough to halt the momentum that had been working against him from the start. The judge returned his focus to the document and read portions aloud, carefully, deliberately, as though speaking the words would help him process their implications. His voice no longer carried the clipped impatience of earlier proceedings. Instead, it held a measured caution, tinged with disbelief at what the pages revealed. The name at the center of it all seemed to freeze the air. He read it twice, slowly, then paused, allowing its weight to settle over the courtroom. When he resumed, he asked sharply why this information had not been presented in earlier hearings, why it had not been included in the original summary, why it was tucked away in supplemental reports rather than woven into the case file he had relied upon. The prosecution shifted uncomfortably, offering vague explanations about oversight and clerical delays. Their discomfort did not go unnoticed, especially not by the judge, who now regarded them with a gaze that bordered on suspicion. The judge's posture changed again, back straightened, voice firm, expression sharpened by a newfound seriousness. His unease was evolving into something else, determination. Determination to understand how he had been placed in such a precarious position, determination to find out who had neglected to present critical evidence, determination to probe the truth behind the name that had disrupted the entire hearing. The defendant felt his heartbeat accelerate. For the first time, he wasn't the target of the judge's scrutiny. The focus had shifted elsewhere, and yet he remained cautious, not daring to let hope fully emerge. He had seen things go wrong before. He had felt the crushing weight of misinterpretation, dismissal, and disbelief. But now the truth he had been trying to reveal for so long was finally in the hands of the person whose decision held the power to reshape his future. The judge removed his glasses, rubbed the bridge of his nose, then placed them back on with the air of someone re-evaluating everything he thought he understood. He looked to the clerk with a nod of acknowledgement, a silent recognition of her courage in insisting he look at what he had tried to brush aside. Then he looked to the attorneys, his gaze heavy with expectation. He demanded explanations, demanded accountability, demanded clarity. And the courtroom shifted again. The earlier energy, quick, rushed, indifferent, was gone. In its place was something intense and almost electric, the sense that the hearing had transformed into something far larger than a simple procedural matter. The judge turned back to the document once more, rereading the name that had shaken the foundation of the case. The name belonged to someone with influence, someone with connections that extended far beyond the walls of the courtroom, someone whose involvement in the case was not just unexpected but deeply alarming. And as the judge absorbed this truth, his unease deepened, not just because of the name itself, but because of what it meant for the integrity of the proceedings. He had allowed himself to be rushed. He had allowed the simplest version of the case to guide him. He had come dangerously close to making a decision that would have been catastrophically unjust. The judge's hand tightened slightly around the file. He realized in that moment that he could not trust the narrative he had been presented. He could not rely on the prosecution's summaries. He could not ignore the defendant's persistent attempts to speak. And he could not unsee the name that now dominated his thoughts. The entire courtroom seemed to lean forward as the judge prepared to speak again, his voice no longer rushed, no longer irritated, but carrying the weight of a man who has just discovered the ground beneath him is not as stable as he believed. When the judge spoke the name aloud, everything stopped. The sound of it dropped into the room like a stone plunging into dark water. Heavy, echoing, impossible to ignore. The gallery froze mid-breath. The attorneys stiffened. Even the air seemed to thicken around the syllables, as though the courtroom itself recognized their gravity. The defendant's eyes widened. He had known this moment would be shocking, but witnessing the collective realization ripple across the room was something entirely different. The name belonged to someone whose involvement in the case should have been impossible. Someone with authority, stature, influence. Someone whose presence in those documents reframed the entire narrative. And in the span of a few seconds, the courtroom's understanding of the case shifted dramatically. What once appeared to be a straightforward matter of charges and evidence now revealed itself as a tangled web of connections that reached far beyond the defendant. The judge's voice faltered ever so slightly as he read the name again, his tone carrying disbelief and a flicker of concern. The implications were staggering. The prosecution exchanged uneasy glances, their earlier confidence evaporating. They had not expected the document to surface. They had not expected the judge to read it, and they certainly had not expected the defendant's claims to gain the power of confirmation. The defense attorney sat forward, eyes sharp, ready to seize the moment, but careful not to appear triumphant. He knew this wasn't victory yet. It was merely the removal of a blindfold. The judge closed the file with deliberate care, as though the document were fragile, dangerous, capable of igniting something irreversible. And in truth, it was, because now everyone in the courtroom understood that this case was not just about a single defendant. It was about influence, interference, and truths that someone had tried very hard to bury. The name hung in the air long after the judge stopped speaking, reshaping everything the courtroom thought it knew. The moment the name was spoken, the defendant felt the atmosphere tilt toward him in a way it never had before. For so long he had been dismissed, talked over, rushed through, treated like someone grasping at straws. But now, with the judge staring at the document as if it had rewritten the entire case, the defendant watched the shift unfold like a slow sunrise. His attorney leaned forward, sensing the same change, ready to amplify every detail the defendant had been struggling to communicate. The courtroom's earlier skepticism dissolved into an uneasy curiosity, and for the first time, the defendant's words carried weight. He repeated parts of his story, carefully this time, every sentence landing with a new gravity. Each detail that once sounded like desperation now resonated with chilling plausibility. The judge listened, really listened, his gaze fixed not on the clock but on the man whose fate he nearly sealed too quickly. Even the prosecution hesitated, no longer interrupting or dismissing him. Their silence was an admission within itself. The defendant felt his voice steady as he spoke. The room leaned in. His fragmented narrative, once scattered and ignored, now aligned seamlessly with the truth hidden in that document. He could feel the shift inside himself, too. Fear transforming into a fragile but undeniable sense of validation. The courtroom, moments earlier rigid and controlled, now felt like it was unraveling thread by thread. The name in the document had torn open a seam, exposing questions no one wanted to face. The prosecution's timeline faltered under scrutiny. Previously unquestioned statements suddenly looked incomplete. Motives that made no sense before clicked loudly into place. The judge flipped through the file again, this time searching, not rushing for what else he had overlooked. Every page seemed to contradict the certainty with which the case had been pushed forward. The defendant's attorney seized the opportunity to highlight inconsistencies long ignored. Witnesses listed but never contacted, messages referenced but never subpoenaed, an entire chain of events reframed by the identity revealed in that file. The prosecution struggled to regain footing, offering explanations that fell flat the moment they left their lips. The judge's expression hardened, not with anger at the defendant, but with a dawning awareness of how precariously the truth had been handled. The case, once streamlined and simple, was now a maze of errors, omissions, and connections that demanded deeper investigation. The courtroom felt the unraveling as acutely as the judge did. A narrative, once shaped by assumption, had fractured, revealing a truth far too complex to ignore. The judge's breath tightened as he reread the documents, realizing how close he came to ruling without understanding the full truth. His earlier confidence now felt like a weight pressing against his chest. He looked at the defendant with a mixture of regret and urgency, acknowledging, without words, that he had nearly allowed haste to eclipse fairness. His authority no longer felt like a shield, it felt like responsibility he had momentarily mishandled. The courtroom sensed his shift, the quiet admission that he needed to reevaluate everything from the ground up. A stillness swept through the room, thick and absolute. People exchanged glances, but no one dared speak. Even the soft shuffling of papers ceased as the reality of the revelation settled over everyone. The prosecution stiffened, the defense held its breath, and the defendant sat frozen as though afraid to break the fragile moment. The silence wasn't empty, it was charged, alive with shock and recognition that the case had just transformed into something far more serious than anyone had expected. The courtroom had transformed into something unrecognizable from its initial state of brisk efficiency. The hurried, clipped proceedings that had dominated the morning were replaced with a tense, almost electric atmosphere, each movement charged with consequence. The judge's earlier impatience and dismissal had been shattered by the discovery of the crucial document and the name it revealed. He had leaned back, processed the implications, and then realized the enormity of his oversight, not just as an individual, but as a representative of a legal system designed to deliver fairness and justice. He was now acutely aware that the system's machinery, which often operated smoothly when routine cases passed through without incident, could be perilously fragile when confronted with unforeseen details. What had seemed like minor procedural missteps, overlooked evidence, rushed hearings, and cursory reviews now felt like a potential threat to the very foundation of judicial integrity. Every participant in the courtroom understood that the stakes had suddenly escalated. The prosecution, who had entered the morning confident in the simplicity of their narrative, now faced the gnawing realization that their assumptions had been incomplete, that critical information had been ignored, and that the defendant's credibility had been dramatically restored. They whispered among themselves, trying to reconcile the calm confidence with the glaring exposure of overlooked details. The defense, meanwhile, exhaled collectively. After so many minutes, so many hours of feeling unheard and dismissed, they were finally being given the attention the situation demanded. Their arguments, previously brushed aside, now resonated with clarity and importance. Every point they had struggled to make found reinforcement in the document's revelation, and the courtroom responded, even unconsciously, to the shift in balance. The judge's demeanor had changed entirely. No longer the rapid, imperious figure who had opened the case with the certainty of predetermination, he was now cautious, deliberate, acutely aware of the responsibility he bore not only for the defendant, but for the integrity of the legal process itself. He reread sections of the file, pausing to cross-reference statements, motions, and prior submissions. The realization dawned that in his rush he had inadvertently silenced voices, overlooked details, and allowed assumptions to carry the weight of fact. It was an unsettling awareness, one that gnawed at him quietly, even as he maintained a measured exterior. The courtroom responded to the change with its own subtle shifts. Observers who had initially been passive participants became alert, acutely sensitive to every gesture, every word, every subtle inflection in the proceedings. The defendant felt it too, a growing awareness that the room's attention had pivoted in his favor, that the weight of truth now supported him, and that every argument previously ignored was suddenly relevant and pressing. The gravity of this realization was almost suffocating. He could see it in the eyes of the jury members, in the slightly trembling posture of witnesses, and in the way attorneys adjusted their papers with careful deliberation. The clerk, who had first recognized the importance of the document, stood silently, her role in the unfolding revelation unnoticed by most but pivotal in the progression of events. Her courage had catalyzed the shift from rushed judgment to careful consideration, demonstrating that even those perceived as secondary participants in the judicial process could profoundly influence outcomes. The judge's acknowledgment of her intervention was subtle but significant, a nod of respect, a brief exchange of eye contact that conveyed understanding without words. It was a quiet recognition that the system, for all its formality and hierarchy, depended on individuals who exercised vigilance, conscience, and courage. As the hearing continued, the judge requested additional review of previously overlooked materials, instructing both sides to provide clarifications on points that had initially seemed minor, but now carried amplified significance. The defendant's attorney meticulously highlighted relevant evidence, ensuring that every connection was clear, every implication fully understood. The prosecution, while initially resistant, complied with the renewed scrutiny, presenting explanations and attempting to reconcile gaps in their initial presentation. The courtroom had evolved into a space where procedural rigor and deliberate attention replaced speed and assumption, transforming the hearing from a perfunctory exercise into a meticulous pursuit of truth. The implications extended beyond the immediate case. The judge recognized that this single oversight could serve as a cautionary example for the broader legal community. In a system where efficiency often competes with thoroughness, there existed a latent risk that critical evidence could be ignored, that lives could be affected, and that justice could be compromised. The document, with its singular revelation, had forced a recalibration, not only for the current case but for the approach and mindset applied to every case reviewed under similar pressures. It was a stark reminder that the law's effectiveness relies not merely on codified procedures, but on the attention, judgment, and integrity of those who enact and interpret it. The defendant, for his part, experienced a profound shift in perspective. The earlier feelings of helplessness, of being trapped by an indifferent system, gave way to a cautious sense of validation. Each word he had spoken, each detail he had attempted to share, now found resonance within the courtroom. The very name that had been nearly overlooked became a fulcrum upon which the balance of justice had shifted. He understood acutely the fragility of procedural oversight and the importance of persistence, preparation, and advocacy in navigating the judicial system. His experience underscored the reality that justice is not a static guarantee, but a process demanding vigilance from all participants. As deliberations continued, the interactions among the legal professionals in the courtroom reflected the newfound gravity of the moment. Attorneys revisited earlier assumptions, questioned initial interpretations, and recalibrated strategies in light of the revelation. Witnesses were asked to clarify and expand upon statements that had previously seemed peripheral, demonstrating that even seemingly minor details could carry profound implications when viewed through a lens of comprehensive scrutiny. The courtroom functioned as a microcosm of the broader legal ecosystem, a space in which the interplay of attention, diligence, and conscience determines whether outcomes reflect fairness and truth. The judge's role evolved with each passing moment. No longer a figure rushing through procedural obligations, he became an arbiter attuned to nuance, sensitive to context, and aware of the consequences of every decision. His questioning became measured, his instructions deliberate, and his tone tempered with the awareness that authority must be exercised with both rigor and humility. The discovery of the name in the supplemental document had disrupted not merely a single hearing but the judge's perception of the judicial process itself, challenging him to reconcile prior assumptions with emergent truths. Observers in the courtroom sensed the transformation. Those who had anticipated a perfunctory, rapid resolution were now witnesses to a process in which the system itself appeared to be recalibrating. The air was charged with a tension that was not adversarial, but anticipatory, a collective recognition that the path to justice required patience, reflection, and responsiveness. Even minor gestures, the careful turning of pages, the deliberate phrasing of questions, the attentive posture of attorneys and witnesses, conveyed a heightened awareness that every action could influence the final outcome. The defendant's attorney worked meticulously to reinforce the connections highlighted by the document. Each piece of previously overlooked evidence was placed into context, demonstrating a coherent narrative that aligned with the defendant's account. The clarity this brought to the courtroom created a palpable shift in perception. What had been treated as an isolated case of alleged misconduct now revealed itself as a situation of broader significance, emphasizing the importance of thorough review, diligence, and careful judgment in the administration of justice. The prosecution, initially confident, now contended with the necessity of addressing gaps and inconsistencies. Their strategies evolved in real time as they attempted to reconcile prior positions with the emergent understanding of the case. The courtroom, previously characterized by rapid, surface-level engagement, now became a forum for careful examination, discussion, and clarification. Each participant adjusted to the new tempo, recognizing that the proceedings had shifted from a procedural exercise to a substantive assessment of truth. The defendant experienced a profound mixture of relief and cautious optimism. His efforts to provide evidence, to present testimony, and to assert the importance of previously ignored details had finally been acknowledged. The supplemental document had acted as a catalyst, not merely for the case at hand, but for the broader recognition of procedural fairness and thorough review. In witnessing the shift, he understood that individual persistence, combined with the courage of others, in this instance the clerk, could exert a transformative effect on a system that often prioritizes efficiency over depth. As the judge continued to engage with the document, the courtroom maintained an atmosphere of heightened focus. Each word, each movement carried weight. The participants understood that the integrity of the judicial process was under scrutiny, not as an abstract principle, but as a lived reality impacting human lives. The supplemental document, once nearly dismissed, now served as a pivotal reference point, influencing lines of questioning, clarifying ambiguities, and reshaping the trajectory of the hearing. The unfolding events also highlighted the interdependence of courtroom roles. The judge, attorneys, clerks, witnesses, and observers each contributed to a dynamic interplay in which diligence, attentiveness, and moral courage intersected with procedural frameworks. The revelation of the name emphasized the necessity of collaboration, the importance of advocacy, and the centrality of truth in guiding decisions. No single participant could claim sole responsibility for the outcome. Rather, it was the convergence of preparation, observation, and ethical engagement that ensured a more accurate and just process. The courtroom, in its transformation, exemplified the delicate balance between authority and accountability. The judge's initial haste had threatened to overshadow the defendant's voice and the integrity of the case. Yet the intervention of the clerk, the persistence of the defendant, and the careful re-evaluation of evidence collectively underscored the system's capacity for self-correction when individuals acted with courage and responsibility. It was a demonstration of how procedural oversight, vigilance, and conscientious engagement could restore equilibrium and realign outcomes with the principles of justice. The defendant, now more confident in the recognition of his narrative, continued to provide testimony and clarification with renewed focus. Each statement he made resonated more strongly because the courtroom had acknowledged the importance of previously overlooked evidence. The interplay of document, testimony, and judicial attention created a cohesive understanding that had been absent at the hearing's outset. The supplemental document's impact extended beyond its immediate content. It reshaped perceptions, clarified motives, and provided a foundation upon which the judge could base decisions with confidence that all critical information had been considered. The legal system, represented in microcosm by this courtroom, demonstrated its inherent capacity for correction and adaptation. The judge, initially hurried and dismissive, recalibrated his approach in response to evidence and intervention. Attorneys, witnesses, and clerks each contributed to the emergence of a more accurate and equitable understanding. The defendant, whose voice had been nearly lost to procedural haste, was finally given the recognition and attention warranted by the case's complexity. The supplemental document, once underestimated, became a symbol of diligence, accountability, and the importance of advocacy. It highlighted the potential consequences of oversight while simultaneously offering a pathway to correction. Through careful attention, ethical intervention, and persistent advocacy, the participants collectively ensured that the hearing evolved from a potentially flawed, hasty proceeding into a deliberative, informed, and more just examination of the facts. The courtroom's energy remained taut, charged with the realization that oversight could not be allowed to dictate outcomes. The judge, now fully attentive, reviewed connections, clarified inconsistencies, and sought additional context where necessary. The defendant's attorney continued to reinforce critical points, ensuring that the narrative aligned with corroborated evidence. The prosecution adjusted strategies, acknowledging the gaps revealed by the supplemental document while attempting to maintain credibility within the reoriented proceedings. The unfolding events underscored a fundamental principle of the legal system, that justice is contingent not only on codified procedures, but also on the diligence, ethical engagement, and attentiveness of those who operate within it. The supplemental document had forced a recalibration, prompting participants to confront assumptions, review overlooked evidence, and approach the hearing with heightened responsibility. The courtroom became a space where deliberation, reflection, and integrity intersected, demonstrating that even in a system constrained by structure and hierarchy, individuals could influence outcomes by ensuring attention to detail and ethical conduct. The defendant, observing these developments, understood the broader implications. His experience was a testament to the necessity of persistence, preparation, and courage in advocating for oneself. It illustrated how overlooked evidence could have profound consequences, and how intervention, even from a seemingly peripheral figure like the clerk, could catalyze transformative change. The recognition and careful review of the supplemental document ensured that the hearing no longer relied on assumptions or expedients, but engaged fully with the complexity and nuance inherent in the case. The judge, having absorbed the significance of the document and the implications of his earlier haste, now approached the remainder of the hearing with measured deliberation. His questions were precise, his review thorough, and his attention unwavering. The courtroom, having shifted from hurried proceedings to a deliberate assessment of fact and context, functioned as a microcosm of what the legal system strives to achieve when procedural rigor aligns with ethical engagement. The interplay of all participants, guided by the revelation in the supplemental document, reinforced the importance of vigilance, conscientious intervention, and integrity. It highlighted the potential for a system designed to deliver justice to falter when assumptions override careful attention, and conversely, its capacity to correct course when individuals act with awareness and moral courage. The courtroom became a living example of these principles in action. The defendant, now more engaged, continued to clarify and confirm details, supported by his attorney and validated by the judge's renewed attentiveness. The prosecution, adjusting strategies in real time, acknowledged prior oversights while attempting to maintain coherence in their arguments. The clerk remained an unassuming but pivotal presence, demonstrating the power of conscientious action in shaping outcomes. The supplemental document, central to the unfolding events, underscored the necessity of diligence and vigilance in ensuring that justice is administered fully and fairly. The courtroom's proceedings, having shifted from a rapid, superficial engagement to a deliberative, conscientious process, exemplified the delicate balance between procedural structure, human judgment, and ethical responsibility. Every participant, judge, attorneys, clerk, defendant, and witnesses, contributed to a recalibration that elevated the hearing from a potential miscarriage of justice to a rigorous, informed examination of the case's complexity. The supplemental document had become both a catalyst and a guide, illuminating the path toward clarity, fairness, and accountability. The transformation of the courtroom, the recalibration of the judge's approach, and the validation of the defendant's narrative demonstrated the fundamental principle that justice requires attentiveness, ethical engagement, and the courage to confront assumptions. The supplemental document had forced a reckoning not only with the specifics of the case, but with the broader implications of oversight, haste, and procedural neglect. It highlighted the capacity of individuals to influence systemic outcomes through diligence, persistence, and moral courage. The courtroom remained charged with the energy of recognition, awareness, and recalibrated focus as participants continued to navigate the hearing with renewed commitment to accuracy, fairness, and thoroughness. Every action, every question, and every response reflected a heightened understanding that the integrity of the judicial process depends on the careful and conscientious engagement of all those who participate within it. The supplemental document had revealed a truth that demanded attention, reshaping perceptions, influencing deliberations, and compelling the courtroom to act with heightened responsibility. It had catalyzed a transformation in proceedings, highlighting the critical importance of vigilance, ethical conduct, and comprehensive review in the administration of justice. The courtroom, once dominated by haste, assumption, and routine, had evolved into a space where deliberation, accountability, and conscientious attention guided the assessment of evidence, testimony, and argumentation. The supplemental document, once nearly overlooked, had reshaped the narrative, restored credibility, and reinforced the principle that justice is contingent on the careful, ethical engagement of all participants within the legal system. The defendant, witnessing the recalibration of focus and attention, recognized the interplay of preparation, persistence, and advocacy in shaping outcomes. The courtroom, through the combination of individual courage, diligent review, and ethical responsibility, had begun to reflect the principles of justice that the system aspires to achieve. The proceedings continued with careful deliberation, attention to detail, and recognition of the profound significance of the supplemental document. Each participant, judge, attorneys, clerk, defendant, and witnesses contributed to the meticulous reassessment of the case. The courtroom functioned as a living demonstration of the potential for oversight to be corrected, assumptions to be challenged, and justice to be more fully realized when participants engage with integrity, vigilance, and conscientiousness. The supplemental document had emerged as the linchpin in a hearing that had begun with haste, assumption, and dismissal. Its presence reshaped deliberations, restored credibility, and reinforced the principle that truth, diligence, and ethical intervention are indispensable to the administration of justice. The courtroom, transformed by the unfolding events, exemplified the capacity of the legal system to reconcile oversight, reassess evidence, and approach decisions with renewed rigor and integrity. The hearing, now conducted with careful attention to the implications of every document, testimony, and argument, became a microcosm of what justice strives to achieve when individuals act with diligence, moral courage, and conscientious engagement. The supplemental document had forced a reckoning, not only with the specifics of the case, but with the broader responsibilities inherent in the judicial process, demonstrating that attention, preparation, and ethical vigilance are essential to ensuring outcomes that reflect fairness, truth, and accountability. If this story gripped you and left your mind racing, don't let it end here. Smash that like button to show your support and help this video reach more viewers who love real, shocking courtroom stories. Hit subscribe and turn on notifications so you never miss a moment from A1 Storyteller, where hidden truths and unbelievable twists come to light. I want to hear from you. Comment below with what shocked you the most, or share how you think the case could have gone differently. Share this video with friends or family who love jaw-dropping stories, and join the conversation on our community page. Every interaction helps us uncover more incredible narratives that demand to be told. Remember, your voice makes this channel stronger. Engage, react, and be part of the story. The next shocking revelation is just around the corner, and you won't want to miss it.